The appellant. I'm Ramesh, Kanna, and I act for the appellant, Mr. Antonio Fortuna. I'll bring you through the first two issues on the appellant side, and my co-counsel, Mr. Brandon Zhang, Mr. Austin Seah, apologies, will bring you through the last two issues for the appellant side, also for 10 minutes, and we respectfully reserve 1 minute for rebuttals together.
How long are each of you taking?
Each speaker takes 10 minutes, Madam Arbitrator, and each team as a whole reserves 1 minute for rebuttal.
Okay.
Good evening, members of the panel. The case that confronts us today requires the panel to take a stance on this sliding scale between procedural justice and substantive fairness. Now, the appellants recognize that in the overwhelming majority of cases, the position to be taken has already been concretized under the CAS Code and the FIFA Disciplinary Code. However, this balance does shift in cases with exceptional circumstances. And our argument today is that this case falls under such exceptions. In this regard, I have two submissions. Firstly, the statement of appeal is admissible via the remedy of reinstatement. And secondly, Mr. Fortuna's refusal to hand over his phone was not unlawful, and no adverse inference can be drawn from this. With regard to my first submission on the admissibility, I make it on two grounds. Firstly, reinstatement is a recognized remedy. And secondly, the conditions for reinstatement are met. The appellant does not contend the fact that the statement of appeal was not filed within the 21-day deadline, as ascribed under Article 50, subsection 1 of the FIFA statute. Although filing was attempted within this window period, it was never received by the CAS office because a cyber attack had prevented the email from ever being sent out from the appellant's legal counsel's sphere of control. Thus, as per R31 of the CAS Code, this would not constitute a valid filing. However, the remedy of reinstatement remains available to the appellant. We note that as per the CAS Code and the FIFA statutes, a prayer for reinstatement is not expressly prohibited. Albeit both prohibiting an extension of deadlines, reinstatement, in the matter of reinstatement, both provisions remain silent. Now, we do note that as per CAS jurisprudence, opposing counsel may rely on the 2019 CAS decision of PFC and UEFA, which takes a more extreme approach in stating that in the interest of equal treatment and legal certainty, extra time should not be provided to one party, and therefore reinstatement should not be recognized as a remedy. However, even in this extreme case, under paragraphs 83 and 84, which can be noted in our legal authority number 4, the panel does not take an extremist stance in that they do recognize if there are good reasons an exception can be made. And this was interpreted in the following case in 2024 under the CAS decision of FC Football Club and Galatasaray AS, where the panel came up with two
Question for the appellant, which is what are these good reasons? Can you summarize for me, perhaps in general, what did the court say? What did the tribunal say about these good reasons?
Yes, Madam Arbitrator. So there are two elements to be met in order for the remedy of reinstatement to be available. Firstly, it must have been no fault of the appellant that the statement of appeal was filed late. And secondly, the request for reinstatement must have been made promptly. Now, with regard to the no fault requirement, the threshold is one that is admittedly high. It is not sufficient for the appellant to claim that he was not the cause of the delay. Rather, the central principle is one of foresight. Thus, even if there is a delaying occurrence, if it could have been prevented with foresight, then this onus falls on the appellant. Now, in this regard, in present, the reason why the email was not sent on time was because of a third-party cyber attack. And we do understand that in this modern age, these attacks should be foreseen. And aligned with this requirement, my client and its legal counsel did take all efforts to meet the industry standards for cybersecurity protection. And it's to be noted that this is an uncontested fact under Procedural Order Number 1 at page 62 of the record, if I could refer the panel to it. Thus, the no-fault requirement in this case is met. The more contentious element would be the promptness requirement. If I could refer the panel to page 52 of the record, this would show Exhibit 9, which is a screenshot that evinces a conversation between the IT team and the appellant's legal counsel. Now, in this, we see that the IT team believes that there was a disruption and that this disruption has ended on the 26th of April. Yet, the statement of appeal was only submitted for reinstatement on the 28th of April. Opposing counsel may seek to say that these 2 days is a delay that does not meet the promptness requirement. Now, in this regard, we note that the promptness requirement does not have a set threshold under CAS jurisprudence. The requirement is merely that the panel has to be satisfied of any reasons that the appellant had for the delay. And at present,
So could you tell us what is the reason that you are giving for this 2-day delay?
yes, Madam Arbitrator. So the cyber attack was of a magnitude that affected all the ongoing cases that the appellant's legal counsel had going on at that point in time. Thus, it was not this email that was the only email which was targeted. There were other emails in other cases that were also targeted. Thus, a 1-day delay.
Actually, where do we see this on the record that there were other emails that were also affected?
If I could refer you to Exhibit 9 of the record, Madam President,
Okay,
the
what page is
message
that?
from the IT personnel, it states that
Which page, sorry?
it's at page 52 of the record, Madam President.
Okay, one sec. Yeah, I'm there.
Yeah, in the message from Mike IT, it stated that the cyber attack incident recently occurred and had impacted your email servers.
It doesn't say it has
And
impacted. It says it may have impacted. So we don't know for sure whether it impacted or not. Is this all that you have?
Also, to add on to what Madam President just said, right? It says it impacted your email servers. There's no mention, I believe, about other affected parties or other email servers. Is there something else that you can point us to that shows that there were other customers of this vendor that were also affected?
I understand that there are two questions put forth by the panel. I'll address Madam Arbitrator's question first. It's not our argument that there are other vendors who are affected, Madam Arbitrator. Rather, this vendor, which provides cybersecurity protection for the legal firm, has undergone a cyber attack which has prevented multiple emails in multiple cases from being sent over by the legal firm. As given the fact that many cases are affected, similar reinstatement requests and communications have to be made by the legal firm to various stakeholders.
How do
Therefore,
we know that many cases were affected?
because
Like,
it states here that email servers were affected, we crucially pinpoint the fact that it states in plural rather than a particular email having been affected.
just because the servers were affected does not necessarily mean that multiple cases were affected. And I do want to point out the fact that it says may have been impacted. So we still don't know conclusively that things were actually affected by this cyber attack.
I understand that goes towards the earlier question Madam President had. And the fact that there was a cyber attack is also corroborated by the CAS office, which has stated that it did not receive the statement of appeal. And it's an
No,
uncontested
that
fact
does
that,
not corroborate the fact that there was a cyber attack. It only states that they did not receive it. It does not mean that because of a cyber attack they did not receive it.
understand, Madam President, could I refer you to page 62 of the record? Under clarification 6, it states that this cyber attack was a one-time incident and there was no prior history of a similar disruption. Thus, it's an uncontested fact that the cyber attack did occur. However, we do understand that that we cannot prove that multiple cases had been affected. Nevertheless, we invite the panel to look at the equities of the case. The
I think,
underlying principle behind the
sorry, I think
prohibition.
what Madam President was trying to say is not so much about the scope or the reach of the cyber attack, but how are you going to prove causation that the cyber attack is what caused the delay?
We note the concern, Madam Arbitrator, and in this regard, this is the highest that I can take this particular argument with regard to the facts. We do understand that this evidence may not be convincing enough to convince the panel that there was indeed a disruption to the emails. However, we would like to draw the panel's attention to the fact that a hard copy of the statement of appeal, I note that my time has just elapsed. Could I request for an extra 2 minutes just to answer this question and to sum up my submissions under the second issue? The hard copy of the statement of appeal was still submitted just 1 day after the deadline for the electronic filing. Thus, when we look at prejudice, the opposing counsel did not suffer any substantive prejudice because they were only prevented from getting the statement of appeal 1 day late. And when we look at the consequences for my
Sorry,
client,
what is your reason for submitting the hard copy 1 day late?
no, Madam President, the hard copies deadline is as per the class code 1 day later than the email filing. Thus, it was submitted within the deadline.
Okay.
And I bring forth this fact to show to the panel that there's no significant prejudice that has been suffered by the opposing panel in order to prevent this panel from hearing the merits of this case, because the consequences of being banned from playing for 5 years is far too severe for the appellant, such that the equities of the case fall within the appellant's favor. Now, moving on to the second issue. The critical point on why the refusal to hand over his phone was not unlawful falls back to the threshold of clear and imminent danger. If there's a clear and imminent danger that his information would be passed on by the FIFA officials to the public prosecutor's office, then his right against self-incrimination under the criminal proceedings would be prejudiced. And in this case, the clear and imminent danger threshold has been met because the FIFA officials have already sent over information collected throughout the course of this investigation to the public prosecutors. And it's to be noted that this is in breach of Article 34 of the FDC on their own confidentiality requirements. Thus, when FIFA is not willing to comply with its own requirements, it is wholly fair for the appellant to fear for his right being prejudiced and not handing over his phone. And no adverse inference can be made from this because there is a satisfactory reason for the appellant not handing over his phone. Thus, opposing counsel cannot rely on the IBA rules of taking evidence under Article 9, subsection 6. This brings me to the end of my submissions. If members of the panel have any further questions, I would be happy to assist.
Nothing from me.
Just give me 20 seconds. I'm just looking through the respondent skeletals. So what do you say about the respondent's submission here that FIFA already limited this ambit of request and had already respected his right to privacy, in the sense that I believe they're trying to say that FIFA was lawful. And the fact that there's an adverse inference, I think if I were to read issue 1 and issue 2 together, it would mean that we should not, I'm assuming that respondent is saying we should not be admitting this statement of appeal because we can draw an adverse inference about perhaps the state of mind of Mr. Fortuna at the time when he refused to hand over his mobile phone because perhaps he had something to hide, right? So that's the implication, that they had something to hide in his mobile phone, and there are contents in it that could be incriminating towards him. So what do you have to say to that?
I understand that there are 2 questions put forth by Madam Arbitrator. Firstly, with regard to FIFA only requesting relevant data, I refer to clarification 14 on page 63 of the record, Could I refer Madam Arbitrator to it?
63.
They never explicitly stated what the ambit of relevant data is. This unfairly puts the onus on the appellant to decide what relevant data is. And this is unfair because if the appellant's definition of relevant does not coincide with the definition of relevant provided by FIFA, then the appellant now becomes liable to sanctions under the FIFA disciplinary code. Thus, given the fact that FIFA never stated what is the data that they seek, this would not be a valid request. Now, to answer Madam Arbitrator's second question on what's the relevance, what's the link between the second issue and the first issue, the submission of the statement of appeal provides this panel with jurisdiction to hear this issue. That is separate from whether an adverse inference can be drawn from the refusal to hand over his phone. And the adverse inference would go towards the merits of the issue regarding whether this refusal to hand over his phone can be interpreted to mean that handing over the phone would have been counterintuitive to the appellant's case, such that the panel would be entitled to make an inference that is adverse to the appellant's case under the merits. Thus, we would respectfully submit that the first and second issue are not linked.
But is there a requirement that issue 2 can't be talking about the merits, as in the way that the respondent has structured it? How does that affect our proceedings and this current hearing? If we were to rule that we accept the appeal, issue 2 would still stand alone as a merit an issue, right? Like, we still would have to talk about it. So
Yes,
why
Madam
would there be?
Arbitrator. That is indeed our position as well. They stand as separate heads of arguments. They are not
So
affected. They are
we have to say the fact that not the fact, but the submission of the respondent that adverse inference can be drawn. Yes, let's accept that this is a merits argument. This is a merits issue. But what do you have to say about Mr. Fortuna refusing to hand over his mobile phone being something that perhaps he has something to hide, right? To prove his state of mind. Is that something that's relevant for the tribunal? Do we have to look at that issue about the state of mind of Mr. Fortuna?
Give me a moment to consider the question, Madam Arbitrator.
Sure. Because at the end of the day, you're talking about betting and conspiracy, right? Which necessarily indicates some sort of state of mind that you need to prove, or at least the respondent would need to prove. So in that case, it seems to me that the evidence of could have been found in the phone is quite crucial and is critical to prove a case of conspiracy. And the fact that he may have known if he was guilty, right? If he had something to hide, not showing his phone or not surrendering it could be seen as him perhaps knowing that he had something to hide and that he was guilty. Is that something that the appellants are trying to argue for?
I
Or argue
understand the
against?
question, Madam Arbitrator. The respondent counsel would seek to use adverse inference in order to show the state of mind of the appellant. However, the state of mind of the appellant is not relevant in considering whether an adverse inference should be made. Whether an adverse inference should be made depends on two conjunctive conditions. Firstly, there must have been no satisfactory explanation for the refusal to hand over his phone. And secondly, adverse inferences can only be made if there are other pieces of evidence that raise a question to be answered. Now, with regard to the first condition, here, given the fact that the appellant's refusal was aligned with his Article 8 and Article 6 rights under the ECHR, this would prove to be a satisfactory explanation. This is further supported by the fact that FIFA did not explain what the ambit of relevant is. Now, moving to the second condition, respondent counsel would seek to use the evidence of the witness statement, which documents the appellant's conversation with his father and would try to show that this raises a question as to whether he was pressured by the father to engage in match manipulation. However, our submission is that this evidence does not raise any such question because it has already been stated by the appellant in his personal testimony that this conversation was not regarding any such conversation of match manipulation and that him and his father disagree about many things. And this can be corroborated with the fact that players often undergo many conversations of disagreements with their fathers or family members prior to games, even in considering real-life practical scenarios. Thus, this particular evidence is not strong enough to raise a question that the appellant has to answer by handing over his phone. Therefore, his refusal to hand over his phone would not raise an adverse inference.
Okay.
Thank you, Madam Arbitrator.
If I may begin, members of the panel. Good evening, members of the panel. As earlier introduced, my name is Seah, and I'll be continuing the case for the appellant. Turning to the third issue, we submit that the anonymous witness statement and email are inadmissible. Members of the panel, the law treats all anonymous evidence with a degree of suspicion because due to its inherent nature, it is incapable of being tested physically. Therefore,
Which law are you relying on for this proposition?
this proposition is relied upon by two areas of law. Firstly, CARE's jurisprudence on past cases regarding the admission of anonymous evidence. And secondly, under Article 6 of the ECHR 6 subsection 3D, which notes the accused has the right to confront his accuser.
Okay,
In
how
this
is the ECHR applicable to us again? Can you remind me?
Certainly, the ECHR is applicable in our proceedings today, Madam President, because CARE's jurisprudence has to be in line with the principles of Swiss public policy. And noted in the case of Amos Adamau in the CARE's jurisprudence, the 2011 decision of Amos Adamau, CARE's jurisprudence has to be in line with Swiss public policy to ensure that these areas are not appealed to the Swiss Federal Tribunal, which has the ability to overrule CARE's rulings. And therefore, to ensure such no appeals go through, we have to ensure that CARE's jurisprudence is in line with Swiss public policy. And in this respect, there are two elements that must be met for anonymous evidence to be admitted in our case, of which both two have not been met by the respondent. Firstly, there must be a real risk of retaliation, which justifies the need for anonymity. And secondly, the witness must be cross-examined through audio-visual protection. Turning to the first element, following our legal authority number 7, the case of Karim Karimuddin at paragraphs 133, it is noted that there must be at the minimum a real risk. And in that case, objective third-party affirmation went to ascertaining if there's indeed a real risk, as the witness in that case was granted asylum. And this objective third-party affirmation came from the immigration authorities that did recognize that there was a real risk in that case. Now, counsel for the respondent may like to assert that the Iridonia Public Prosecutor's investigation suffices as a third-party affirmation. However, if I may turn members of the panel to page 63 of the record, under clarification 12, it is noted that investigations were only ongoing, and therefore criminal proceedings are not even decided, and therefore it raises a question as to whether the father is an alleged criminal that a respondent paints him to be. And now turning to the second element regarding the right to cross-examination, which is that of audio-visual protection, under our legal authority number 8 of F.K. Pobeda, it is noted that evidence which cannot be cross-examined meaningfully because context is missing cannot satisfy the standard of proof and should not be admitted. And we understand that the witness in himself is fearful of Mr. Fortuna's father. This is precisely why cases such as the 2018 case of KS Scanderbrew and the 2019 decision of Syed Ali confirms that audio-visual protection is not merely a factor, but a strict condition in place to ensure their protection. The rationale given by this court was as such. There's a need to balance between the procedural rights of the accused under Article 6 of the ECHR and to be weighed against the necessity to protect the safety of the witness. Now, audio-visual protection serves that precise purpose, as the witnesses themselves are brought to an undisclosed location with CARE's counsel, where interviews are held in conjunction with CARE's proceedings, which ensures their anonymity. And therefore, this serves as a proper balance which must be in place in today's proceedings. However, on the facts of the case, no such safeguards have been in place by CARES, and this panel has the ability to rectify such issues by virtue of Article R57 of the CARES Code. And without such safeguards, we submit that anonymous evidence should not be admitted in our case. If there are no further questions on the...
Would it change your case if somebody came up and said that, hey, actually, I'm the person that sent the email and it was verified? Would that change your submission?
No, in this respect, we will argue no, Madam Arbitrator, because even in the 2025 CARES decision of Eddie Banda and UCI, the anonymous witness statement in that case was actually identified and tied to an individual who was named in the proceedings. However, the very fact that there was no cross-examination, specifically through audio-visual protection, resulted in the court according this evidence limited evidentiary value. And therefore, it will not be detrimental to our case, even if the witness was to admit his own identity in the email.
So you're saying that as long as there's no criminal trial because there's no cross-examination, then we cannot admit the email even if it's not anonymous?
To be more precise, Madam Arbitrator, it is the fact that there's no cross-examination solely to ensure that the rights of the accused under Article 6, subsection 3 is acknowledged, and therefore, without such safeguards, the evidence cannot be admitted.
But isn't the tribunal also empowered to do cross-examination?
Yes, it is empowered to do cross-examination under Article R57. And therefore, if this panel is able to cross-examine the witness, we will allow the evidence to be admitted. But presently, simply admitting to be the person who wrote the witness statement or the email is insufficient.
And how would that change your case if, say, we are empowered and then we do exercise that power to admit the evidence because we are cross-examining the witness? How would that change your case?
This will go towards my fourth submission on whether a violation of Article 20 can be made out. But to summarize first, it will not damage our case because the evidence in itself does not provide conclusive proof of match manipulation. And to provide further clarity, if I may turn to the fourth issue, we submit that the violation of Article 20 has not been made out. The respondent may attempt to draw a fact barrage and tie loose connections between the various strands of evidence to prove a violation of Article 20. However, the key element which the respondent's case turns on is whether there's a direct or at the very minimum an indirect link between the appellant and the alleged conspiracy to be made out, to which the answer is no. And in this respect, we make two arguments. Firstly, there's no direct or indirect link between the manipulation and the appellant for a violation to be established. And secondly, even if the anonymous email and witness statement is admitted, the standard of proof has not been met to establish such a link. And to first answer, Madam,
that you are seeking to prove conspiracy, what is the standard of proof here?
The standard of proof can be found under our legal authority number 15, specifically the FDC, Article 39, which establishes the standard of proof to be comfortable satisfaction. And clarified by case law, it means this standard of proof is in between what is known as balance of probabilities of 50% and beyond reasonable doubt, the standard of criminal liability. And to illustrate what will amount to comfortable satisfaction in our case, following our legal authority number 10, the 2010 decision of Orikov, the panel relied on a convergence of strong evidence, such as intercepted calls, financial flows, and even findings of state courts to establish a direct link between the appellant and the alleged conspiracy. Now, in our case, as the anonymous witness statement and email cannot be admitted, the respondent can only solely rely on the genius report found in Exhibit 1. And this provides a number of...
What about the usage of the cryptocurrency? Is that not considered, I mean, does that not show that there is some sort of the exchange of the coercion points as well?
Certainly, and I do acknowledge that under the report itself, it did note that it was a BTC that was being transacted, which is essentially Bitcoin. But if we consider what was alleged inside the WhatsApp screenshot in itself, which is Dogecoin, this is essentially a different set of blockchains with different values. And therefore, without any extra evidence showing a tie between these two blockchains in the present case, we submit that it is insufficient to prove an indirect link between the appellant and the father. And earlier, Madam Arbitrator had also questioned, what if we admit the witness statement and the email itself? We would argue that it does not meet the threshold of comfortable satisfaction, because under our legal authority number 8 of FK Pobeda and UEFA, it is noted that witness statements and poor performance cannot meet this threshold. And in that case, the panel had found that the accused was indeed involved in the manipulation, as he had specifically addressed the players of Pobeda to intentionally lose or draw, lest his house would be burned down from the alleged mafia. In contrast, if I may turn the panel to the anonymous witness statement itself, specifically paragraph 9, and this statement can be found at page 33 of the record. The witness statement only goes to show the appellant's refusal to comply. Members of the panel, I do note that my time has elapsed. If I may answer a question and any further questions you might pose. It is noted that the witness statement only goes as far to show the appellant's refusal to comply, even if we were to take the respondent's case at its highest and assume that the appellant's father had indeed threatened the appellant to conspire. And now earlier, Madam Arbitrator had also questioned about whether a mental element is important in establishing whether there's an indirect link. Well, in that respect, we will refer to the 82nd 43-minute inside the genius report itself at page 16 of the record. Now, it is noted that at this juncture, the appellant had managed to save an extremely difficult goal. Now, if he was truly involved in the match manipulation, what he needs to do is to give up the goals at this juncture to ensure a 3-0 victory so that the manipulation is successful. However, he chose instead to save a goal, which goes against the very mental element of required to establish if he indeed wanted to manipulate the match. Now, if there are no further questions on the last issue,
None for me.
this concludes my submissions. Thank you, members of the panel.
Good evening, members of the panel, Madam Arbitrator, Madam President. Am I audible?
Yes, you are.
Shall we begin? Good evening, members of the panel, Madam President. My name is Mark Peter, with my together with my co-counsel, Mr. Brandon Zhang, and we appear for the respondent, FIFA. I will address two issues in 10 minutes, and then I will hand over my time to my co-counsel, Mr. Brandon, to address the last two issues, which is issue C and issue D. In these 10 minutes, I will address whether Mr. Fortuna's appeal is admissible, and issue B will be whether his refusal to surrender his phone was lawful. And we would like to submit that the appeal is inadmissible. Members of the panel, the appeal is inadmissible for three independent reasons. First, the statement of appeal was not validly filed by 23rd April. Second, the reinstatement should be refused because the appellant did not act promptly with utmost diligence once the impediment was known, which was the cyber attack. And lastly, even if the statement was rescued, the appeal brief was late, was
Can
filed
I just check, is this 21 deadline a very strict deadline? Are there no cases where the tribunal has extended this deadline?
Madam Arbitrator, there are cases, but the cases come from a different issue. Here, we are trying to argue that the 21-day deadline was missed, but the appeal brief was also submitted late without any valid reason. And if the appeal brief is submitted late, according to the case law of, according to the 2019, according to the 2019 case law of Club Sportive at paragraph 66, it confirms that the appeal brief, when not filed on time, is deemed inadmissible. So for this specific scenario, we are trying to put forward the argument that in this case, the appeal brief will be inadmissible. Whereas in other cases, there might be certain...
Now, your not your co-counsel, the appellants earlier, I think appellant 1, mentioned that they were within the 1 or 2 day deadline when it came to submitting the physical copy, right?
Yes, Madam Arbitrator.
So why is it not the case that we can refer to the physical copy? Why do we need to refer to the email as the in the counting of the deadline? Can we not use the physical copy instead? Is there some sort of authority that says that the date of the email is the one that we should be referring to when we are calculating whether or not a deadline has been met? Can we not also look at the physical copy?
Madam President, Madam Arbitrator, we are trying to put forward the argument that the CAS Court Office may have received the hard copies of the filing, which were, according to the record, were 5 hard copies, but the email itself, which is the most important part of this submission, was not received.
Wait, why is it the most important part? What's the authority that says that it is the most important? If you say there are 5 physical copies and 1 email, aren't you fulfilling majority of the procedural requirements?
Madam President, could I have a second to gather my thoughts?
Sure.
Madam Arbitrator, I would like to highlight that the CAS Code Rule 31 specifically states that the electronic filing is valid only upon receipt of the CS Court Office. And if CS does not receive this electronic filing, it will be deemed that nothing has been filed. So the authority for my earlier statement is Article Rule 31 of the CAS Code itself.
Okay.
Madam President, so we accept that the appellant's starting point, the timing runs from the receipt of the full grounds. And on these facts, the operative deadline of the statement of appeal was 23rd April. But the problem here is simple. CAS never received the appeal email, so there was no filing. Now, if I may take the panel to page 5 of the PDF, paragraph 29. Is the panel with me? Over here, it says that the CS Court Office states that it never received the appeal email and had not registered the appeal even by 28th April. Now, this is consistent with the legal authority number 2, the 2022 CAS case of Hungarian Football Federation and FIFA. Here, the principle was that the email filing must enter the recipient's sphere of control. But in this case, we don't see that happening. Finally, on page 5 of the PDF at record 31, it tells us that the appellant requested for reinstatement. The request itself concedes the filing, concedes that the filing was not effective and was not done by the deadline. Now, moving on to the utmost diligence and promptness, even if the
Can I
panel,
just clarify?
yes,
The
yes, madam.
email was received late, but what about the documents uploaded to the CAS filing platform?
So, Madam President, could you please repeat the question again?
Sure. So the documents that were sent via email, those were late. So because of the cyber attack, what about the ones that were uploaded to the CAS e-filing platform?
Madam President, according to our knowledge, the documents were not uploaded in time as well. Thus,
Okay.
the overall,
Where can we see that?
Madam Arbitrator, we see that in the case itself, the record, we don't see the documents being uploaded. This only happens, the documents will be uploaded by the CS court office when they have received the email and the hard copies itself. But in this case, there was no hard copy in the first, there was no, the CS, the appellant submitted the hard copies, but the electronic filing was only valid by online, and the online emails were not received on time. Thus, there was no upload of the documents on the court office website itself.
Okay.
Now, Madam President, I understand that I have 4 more minutes left. If I can have an extension of 1 more minute, I will. I would like to wrap both my arguments in this given time. Thank you very much. Now, I understand that the appellant counsel relies and says that they met the promptness and the utmost diligence standard. But I would like to highlight the case of the Swiss jurisprudence case of SFT claimant and FIFA at paragraph 4.2. Here it said that it emphasizes a strict application of appeal deadlines to preserve equal treatment and legal security. Now, the reason I bring this case up is because the promptness standards were not met in this case. Madam Arbitrator and Madam President, if I may lead the panel to page 5, record 27. Over here, we see that the counsel chose to file the submissions at 23:45 hours on the last night. And we submit that if you file 15 minutes before the midnight, diligence requires verifying receipt immediately. That is what a prudent legal professional would do. Second, the appellant's counsel was notified that the cyber incident.
Where do you draw support for this proposition that diligence requires confirming receipt immediately?
Madam President, there is no source which I'm relying on, but rather implying that a legal profession is bound to make sure that all the submissions he's making is made on time. That is of a standard of a prudent legal profession in this sense. So we are saying, and also, according to Swiss law, it is under 1 day to check the email for solicitors itself. Madam President, then also we see that they only contacted the CAS court office on the 28th April, which was a Tuesday, according to page 5 of the PDF, paragraph 30, which was 2 days late. We also understand that the opposing counsel relied on the 2024 CAS case of FC Glatzeri, which is and PFC UFR. But in these cases, it is important to note that there are 2 cumulative conditions. First, the hindrance must not be of the party's fault. And second, the party must seek reinstatement promptly once the hindrance ends. We are not contesting the first point. We are contesting the second point, which is the party must seek reinstatement promptly. Here, we don't see that happening. There is a 2-day gap in the scenario. And we are contesting that the prompt action did not meet the criteria over here. Now, and now moving on to the most vital issue, which is the appeal brief. We understand it is to be noted that Under the CAS Code Rule 51, the appeal brief must be filed within 10 days following expiry of the appeal time limit. The time expired in this scenario on Sunday, 3rd May. So by Rule 32 of the CAS Code, it moved to May 4th, but yet still the appeal brief was filed only on 5th May, according to record para 33. And I would like to highlight the legal authority number 1, 2019 CAS case of Club Sportive at paragraph 66. It said that confirmed the mandatory nature of this rule, which is the late filing of appeal brief makes the whole appeal inadmissible. So, and we also don't see in the record that there was a valid reason given by the appellants if why the appeal brief was late. It was in this scenario, J just only submitted the appeal brief late. Now, Madam President, I understand that I have elapsed my time. If may I have 1 more minute to sum up my issue 2. Thank you very much.
I think taken more than 3 or 4 minutes with the extension, but yes, I mean if Madam President allows it, but I just want you to be mindful that when you say 1 minute, you should keep to 1 minute.
Yes, Madam Arbitrator. Thank you. Madam Arbitrator and Madam President, we would like to highlight that the Article 12 of the FDC imposes a duty to collaborate and provide requested evidence. Mr. Fortuna immediately refused according to record para 20 and maintained the refusal according to record para 21. And under the 2017 CAS case of Jerome Valke at para 277, such refusal constitutes a breach. Now, the opposing counsel also mentioned Article 6 of the ECHR, but ECHR, the threshold for the Article 6 of ECHR is very high. In this scenario, the FIFA proceedings are private disciplinary proceedings and not criminal in nature, which was also highlighted in the Jerome Valke case of Jerome Valke case at paragraph 263. And even where the Article 6 is considered relevant, requires a clear and imminent danger of the circumvention of criminal standards. Here, we don't see that standard being met because FIFA only relayed the documentation and the information they had received on a governance level. And also, I would like to highlight that the public prosecutor refused to share further information with FIFA, which goes to show that there was no collaboration or imminent danger present in this scenario. Now, we would like to submit that the threshold has not been met and Ecuadorian public prosecutors refused to share evidence on paragraph 15 and 16. Thus, we would like to submit that an adverse inference must be drawn under IBA rule Article 19, subsection 7. And Madam President, we would like to submit our argument, and I would like to now hand over my time to my co-counsel, Mr. Brandon Zhang.
Good evening, Madam President and Madam Arbitrator. As introduced earlier, my name is Brandon Zhang, counsel for the respondent FIFA. I will make 2 submissions. First, the anonymous witness statement and anonymous email is admissible. And second, the appellant, Mr. Antonio Fortuna, is liable for match fixing. Turning to the first issue of anonymous evidence, pursuant to our legal authority number 7, Kareem Karimuddin, at paragraph 129, there are 3 elements which must be met to admit anonymous evidence. First, there must be a concrete risk. And second, the evidence is not sole or decisive. And third, there must be counterbalancing factors to safeguard the fair assessment of reliability, namely ID verification and cross-examination. We submit the evidence is admissible for 3 reasons. First, there is a concrete risk. And second, the evidence is not sole or decisive. And third, there are counterbalancing factors to safeguard the fair assessment of reliability. I'll structure my submissions in the 3 parts. Turning.
Can you hear me? Okay, so just on the third point, because just to speed things up, since your opposing side has already said that there's no cross-examination and there's no verification, how can we meet that third limb of the counterbalancing?
Thank you, Madam Arbitrator. Firstly, in Kareem versus FIFA at paragraph 125, panel noted, I quote, the interests of the witness with regard to their life, liberty, and security may be protected by Article 8 of the ECHR. And therefore, if the appellant seeks to rely on Article 6 and 8 to protect the witness, we argue that Article 8, the right to privacy, is also applicable to the witness at hand. And in the 2019 decision of Saeed Ali versus FIFA, at paragraph 152, the panel noted that a Swiss federal tribunal decision decided that the admission of anonymous witness statements did not necessarily violate the right to a fair trial under Article 6 of the ECHR, and stressed that the right of a party to use the anonymous witness statement and to prevent the other from cross-examining such witnesses, if notably the personal safety of the witness requires it. And I note that appellant had cited the Kareem Karamuddin case and submitted on the third-party objective of the affirmation. However, that is distinguishable from the present case, because in that case, the immigration panel granted the witnesses asylum. Here, there is no third party granting the witness asylum, and neither the witness itself may want asylum, because the witness statement has already been identified according to clarification records at page 63 of the record, and they have interviewed and identified him as a member of the Iridonian men's national team. And therefore, where there is a risk to his threat, and there is also a right to privacy, as noted by this tribunal. The anonymous email, and if the panel may now turn with me to page 3, paragraph 13 of the record. Here, the Public Prosecution's Office launched an investigation into the appellant and his father for sports manipulation. And therefore, there is a concrete risk that the prosecution's office here recognized that the father may be connected to a criminal organization as well. And on the next...
Can you help me understand? So is there something that shows when the Iridonian Public Prosecutor's Office launches an investigation, they already have a foolproof case? Where on the facts do we know that? Isn't that just it's just an investigation. There's no charge. There's no concrete evidence yet. I mean, per your own clarification, there isn't concrete evidence, right?
Madam Arbitrator, yes, nothing is suggested on the facts. However, there is if I may direct the panel to page 32 of the record. At paragraph 6, at the last line says, I hear these organizations follow the snitches get stitches rule. And therefore, the witness here is potentially subjected to a risk of physical harm if his identity was to be exposed. And this panel has recognized that in cases of match fixing, where criminal organizations are involved, this could pose a dangerous threat. And we don't pitch our case so high as to say there's a concrete threat. However, we do submit that in these cases where match manipulation is occurring, there is organizations involved which may pose a threat. And the Public Prosecution's Office has a higher standard of proof. So their standard of proof is at the beyond a reasonable doubt, and their criminal proceedings is still ongoing. And therefore, this panel's standard of proof is lower. And it is worth noting their prosecution is still ongoing. And if there are no further questions on this issue, I will proceed to issue 4. We submit the appellant is liable for match fixing under Article 20 of the FDC for three reasons. First, there's a chain of circumstantial evidence. Second, there's a connection between conspiracy and appellant. And third, there's a connection between appellant and his father. I'll structure my submission in two parts. First, the connection between conspiracy and appellant, which is proved by the performance. And then I'll submit on the nexus between the connection between conspiracy, between appellant and the father, which is connected through the crypto and the witness statement. On the performance analysis, if I may turn the panel's attention to page 15 of the record. Here at minute 23, this was the first goal, and here he opted to play from the back. Now, there's no reason why he should opt to play from the back. And on the next page, at page 16, at minute 19:29, here the ball, Fortuna was positioned over the top and opted to shepherd the ball out of play rather than pick up the ball. And then at minute 44 below, at the second line, Fortuna took an unnecessary extra touch, allowing Commonland forward to close him down. And then he attempted a hurried short clearance that was struck directly into the charging forward's chest. And members of the panel, these performances on the pitch shows a very suspicious, unreasonable play. This is not the play that is expected of a professional football player on the pitch. And for these reasons, we submit the conspiracy is made out. And moving on to the second part of the submission, if I may direct the panel's attention to the crypto wallet on page 35 of the record. Here on the page 35, Madam Arbitrator had queried about the crypto earlier. And here we have confirmation. There's the name here that says the syndicate. The message.
The type of currency is not, it doesn't match, right?
The currency doesn't match, but we submit that they often choose to use, we submit it's not fatal to our claim and our case because oftentimes they could easily switch between the cryptocurrencies, and there are various ways to play around with the different cryptocurrencies. And here he acknowledges that he received the last part of the coin. And so there were multiple transfers. So the currency could have been transferred through Dogecoin on other transfers. However, there may have, we submit that it's not fatal to our claim. And lastly,
how do you tell that the father and son are working together in conspiracy? Can't the father be guilty of his own betting with the syndicate, which is separate from his son?
Madam Arbitrator, I note my time is up. May I briefly consider the question and then answer your question, please? Madam Arbitrator, if I may direct your attention to page 38 of the record. Apologize. It is page 32 of the record. Here at paragraph 8 at the bottom, there was a phone call the night before the match. And before the match, there was heard.
But phone call, there is no mention about the phone call being conclusively about the details of the match, right? The last paragraph is, the second last paragraph says, I could not hear what his father was telling me. So the anonymous witness, number one, it is anonymous, so we can't even verify the accuracy of the statement. And number two, we don't even know what the father was actually telling him. So how do we know, and how can we link the fact that they were in a conspiracy? They could be agreeing about something else completely different.
I'll submit on two reasons. Firstly, the father was, it's uncontested that there was pressure being exerted by the father, and appellant was heard refusing pressure. However, appellant could have easily caved into the pressure the next day, and this is supported by the betting anomalies that took place up until the 12 hours prior to the match.
Why
And
do you
secondly,
say that it's uncontested? That it was, yeah, go on.
It is on the facts that he refused pressure. He stated that he couldn't go along with it. However, lastly, in the case of Alexandrina versus PTIOS, the panel held there was match fixing on 4 pieces of evidence. There was suspicious betting reports, performance analysis, poor performance analysis, WhatsApp messages, and Telegram transfers, and the panel took into consideration that the appellant refused to provide her mobile phone, and thus on these 4 pieces of evidence and the refusal to submit her phone drew an adverse inference and held that the appellant was liable. In the present case,
So how do you write off Mr. Fortuna's own statement in paragraph 16 and 17 that they quarrel on basically any topic, they're disagreeable on any topic, and he also clarifies that there is no link at all between his on-field performance and his father's personal interests?
Thank you. We submit that the witness statement is only what he is only hearsay, and we can't simply take that at face value. But secondly, we can also, even though okay, there's two scenarios. Either the father expressly asked him to engage in match fixing, which he denied, and then we submit that he caved into the pressure, followed by the anonymous betting patterns, plus the performance on the pitch, plus the refusal to give the phone. Or alternatively, the father had an argument with him about his diet on the night before, and therefore nothing exists. However, there are still messages and communications on the phone, which appellant refuses to provide, and thus gives the right to draw the inference because this comfortable satisfaction has been met on the 4 pieces of evidence in conjunction with the refusal to provide the mobile phone. This concludes my submissions if there are no further questions. Thank you.
Are members of the panel with me? Members of the panel, I have 2 points in rebuttal. Earlier, Madam Arbitrator had questioned opposing counsel on what is the nexus between the applicant and what's the nexus between the appellant and the conspiracy. This is the weakest part of the opposing counsel's case because it relies on a single piece of evidence to prove the connection between the appellant's father and the syndicate, which is the anonymous email. And this anonymous email, although it has been proven not to have been tampered with, has no proof of origin. The panel is unaware of what the syndicate is. It could have been any other party that could have been named as syndicate under the context. Thus, this evidence goes nowhere in proving that the father had actually taken part in a conspiracy. And this brings me to my second rebuttal, which is that given the merits of this case fall towards the appellant, it would be unfair to prevent the appellant to admit his statement of appeal solely because the opposing counsel received the statement of appeal 1 day late in terms of the hard copy. I conclude my rebuttals.
Can we have the time actually? Is someone recording the time for all the different.
We ourselves are recording the time
Okay, great. Thank
for
you.
each other.
Members of the panel, just one point here in rebuttal. The respondent had submitted on the nexus between the father and the syndicate. However, as noted earlier, there were the messages in the WhatsApp showed that there were more than one transfer of crypto coins. And it did have a title that was named the syndicate. And at clarification records, FIFA did verify the authenticity of the screenshot, which was attached to the anonymous email. This is at page 63 and paragraph 9. And in relation to the statement of appeal, under Swiss policy, under Swiss law, generally solicitors are required to check their email once a day, and therefore they checked on the second day. This concludes my rebuttal. Thank you.
That's one coming together.
Hi, do you guys want a quick break before we go into comment?